pearls of wisdom on our chapter on lien laws. A construction lien is a claim against real property by a contractor or someone who supplied labor and or materials for construction work performed on that real property. The purpose of the Oregon lien law is to make sure people who add value to real property are paid for their labor and materials. When we first saw these lien law notices, when we first encountered it and we had to send out these notices, our general contractors and our customers were very upset. When they got these notices, they thought immediately that we had filed a lien. They always interpreted even the early notices as meaning we were filing a lien. Our general contractors were unhappy because they said, well, why would you think I wouldn't pay you? Of course I'm going to pay you. And then they didn't know how to talk to their customers about it. It caused all kinds of problems. Now we got a very professional way of doing this. And we referred them to the numbers that were on the notices to call so that they could really understand what the law was doing. So we found a way to do it. And we wondered really seriously if we wanted to work with general contractors who did not have enough professionalism to let their customer know in advance that they were likely to be getting these notice of right to a lien. So we asked ourselves, the few people we decided we didn't want to work with, who were really insistent that we not send our right to lien notices so we wouldn't protect ourselves when we went on to the job sites. And they just simply said, well, we don't want to work with you, and we didn't want to work with them either if they were going to do this. So this is something you will have to decide for yourselves. My impression is that this is still going on and that there was a lot of back pressure on subs and original contractors not to start this process, not to protect themselves. It's something you're going to have to decide for your own company. If a contract is $1,900 or under, a contractor does not they never need to deliver the information notice to owner about construction liens to the property owner. Now, why is this? Because if a project is $2,000 or under, you are not required by the state of Oregon to write a contract. Thus, you do not have to send any notices. Do I think you should write contracts for a $1,900 project? Yes, I do. And routinely, we would deliver the notices because we made a commitment to getting this information in our process, and we did both of those things, even though the state of Oregon did not require us to do it. But if the contract is $1,900, if it is $2,000 or less, you are never required to give notices out. A subcontractor must deliver a notice of right to a lien within 8 working days of the start of work. If a property owner paid the general contractor, who in turn did not pay 2 lien holders, the property owner must pay the lien holders again, even though they already paid the general contractor, and then has the right to file a complaint against the general contractor with the CCB to recover the funds paid to the 2 lien holders. Now, this is not a sure thing for the homeowner. The contractor has, if he's a residential contractor, he has a $20,000 bond. So if if he's left town but he was bonded when he did the project, they can get some of their money back, but there are likely to be others who are also seeking reimbursement, so they may not get the full amount that they had to pay twice. The property owner and the mortgagee both get the notice of right to a lien within 8 days of starting the project when a residential subcontractor provides labor and materials. I know the trend is that you don't supply materials, that others supply materials that you install. So please be careful. Inspect those materials before you install them. Check the specs and make sure that they're specified for where you're installing them and how you're installing them. Because when others supply materials, you cannot properly warranty those materials. You didn't supply them. But you certainly are going to be held responsible for installing them properly. Here's a bit of a glossary to remind you of some of the terms that we have used during this presentation. Breach of contract. This means a break of the contract or a failure to perform on the contract. Consideration means something of value is exchanged, usually money and construction services. What is a contract? It is a legally binding agreement between two parties that includes offer and acceptance, consideration, competent parties, and legal purpose. What is intent? Intent is what you were trying to say that you would do in a contract. Legal interpretation is the way a judge understands the purpose of the contract. How does he interpret it? What is a lien? L-I-E-N. It is a claim against real property by a contractor supplying labor and or materials on a construction project. Party. What do we mean when we say party? Unfortunately, not a lot of fun. A party is a person or business who is a participant in a contract. Okay, we have come to the end of Lesson 3. We now have our Lesson 3 exam. On bids and estimates, you will have 6 questions. On contracts, you will have 9 questions. On project management, you will have 5 questions. On lien laws, you will have 5 questions, for a total of 25 questions with 60 minutes to take the test.